Ladies and gentlemen, welcome to this first edition of the ATOZ Video Podcast. The objective is to give you a snapshot of a very topical issue. For this very first edition, we'll walk you through Directive 2018-822 of 25th of May 2018, commonly known as DAC 6, and the draft legislation that was issued by the Luxembourg government on the 8th of August 2019. So what's the purpose of DAC 6? This directive was inspired by the final report on Action 12 of the BEPS project that provides recommendations for the design of mandatory disclosure rules for aggressive and abusive arrangements or structures. DAC 6 requires EU tax intermediaries to report on a mandatory basis specific cross-border arrangements that contain defined characteristics or features and are implemented as from 25th of June 2018. So what is a reportable arrangement? First of all, we need to define what an arrangement is. That term may also include a series of arrangements, and an arrangement equally comprise more than one step. This concept is therefore very broadly construed, and Luxembourg draft legislation doesn't necessarily narrow down the concepts or gives any detailed definition or explanation. The subsequent test is to determine whether the arrangement is cross-border. An arrangement is considered as cross-border if it contains either more than one EU member state or an EU member state and a third country. Once the cross-border dimension of an arrangement has been determined, the key question to assess is whether that arrangement meets at least one of the hallmarks. The hallmarks are set out in the appendix to the directive and describe characteristics or features of cross-border arrangements that might present an indication of a potential risk of tax avoidance. The hallmarks are split into two main categories. On the one hand, the generic hallmarks, which target features that are common to promoted schemes, and on the other hand, specific hallmarks that are known to target weaknesses of the tax system. Many hallmarks have been designed to operate in conjunction with a threshold condition. In other words, many hallmarks trigger disclosure obligations if they fulfill a main benefit test, or MBT. So what's the main benefit test? According to draft legislation, the main benefit test will be satisfied if it can be established that the main benefit, or one of the main benefits, which, having regard to all relevant facts and circumstances, a person may reasonably expect to derive from the arrangement, is the obtaining of a tax advantage. The Luxembourg draft legislation doesn't depart in any way from the DAC 6 directive MBT wording. What the MBT does is therefore to compare the value of the expected tax advantage with the other benefits likely to be obtained from the transaction. This threshold mechanism is meant to filter out irrelevant disclosures and aims at truly targeting tax-motivated transactions likely to pose the greatest tax policy risks. In the presence of a reportable cross-border arrangement, what information will be disclosed? Draft legislation indicates that the information to be communicated to the Luxembourg tax authorities shall contain the following: the identification of intermediaries and relevant taxpayers, details on the hallmarks that make the cross-border arrangement a reportable arrangement, a summary of the content of the reportable cross-border arrangement, the date on which the first step in implementing that cross-border arrangement was made or will be made available, details of the national provisions that form the basis of the reportable cross-border arrangement, the value of the cross-border arrangement, the identification of the member states, of the relevant taxpayers, and any other member states which are likely to be concerned by that cross-border reportable arrangement, together with the identification of any other person in the member state, if any, that is likely to be affected by the reportable cross-border arrangement. While this list is very factual, it also raises some interpretation issues as to how, for example, the value is determined. And then comes the $1 million question. Who has to report? The reporting responsibilities generally rest with the tax intermediary, unless reporting would be in breach of professional legal privilege. Where this is the case, the intermediary has to notify any other intermediary, or where there is none, the relevant taxpayer, that the reporting obligation would then be shifted onto them. An intermediary is defined as any person that designs, markets, organizes, or makes available for implementation or manages the implementation of a reportable cross-border arrangement. DAC 6 and the draft law further extends the scope of intermediaries to any persons that know or could reasonably be expected to know that they have undertaken to provide directly or by means of other persons aid, assistance, or advice with respect to the designing, marketing, organizing, making available for implementation, or managing the implementation of a reportable cross-border arrangement. As you will have understood, the term tax intermediary is very broad and includes any professional that provides tax advisory services. This broad definition of the term intermediary may likely result in overlapping reporting obligations. And according to the draft law, when there is more than one intermediary, the obligation to file information on the reportable cross-border arrangement lies with all the intermediaries involved. Intermediaries are exempt from their reporting obligations to the extent they can prove that the same arrangement has already been reported by another intermediary in possibly another jurisdiction. This obviously requires a certain degree of coordination between intermediaries in order to determine whether or not a cross-border arrangement is reportable, and if so, to ensure that only one intermediary files a report, so as to avoid multiple filings in relation to the same arrangement. The reporting obligations under the draft law are limited to intermediaries that have an EU nexus, based on tax residency, incorporation, or the likes. Hence, non-EU intermediaries do not have any reporting obligations under the directive. In these circumstances, a potential reporting obligation would be shifted to the taxpayer benefiting from the cross-border arrangement. Likewise, when there is no tax intermediary because, for instance, the taxpayer designs and implements a scheme in a house, the reporting obligation rests with the taxpayer who benefits from the arrangement. Who has the right to benefit from the legal professional privilege? According to draft law, lawyers may rely on their legal professional privilege and have the right to an exemption from filing information on a reportable cross-border arrangement. In that case, lawyers acting as intermediary must notify within 10 days their exemption to any other intermediary, or, if there is no such intermediary, to the relevant taxpayer. In that case, the obligation to file information on a reportable cross-border arrangement will lie with the other notified intermediary, or, if there is no such intermediary, with the relevant taxpayer. Moreover, even if the exemption is applicable, the draft law provides that lawyers are nevertheless required to provide general information about cross-border arrangements that do not allow the identification of the related taxpayers. Finally, it's worth noting that in their quality of relevant taxpayers subject to the reporting obligations, clients can still mandate their lawyers to perform the reporting duties on their behalf. In such cases, the reporting will be done by the lawyer acting as a special proxy of the taxpayer. When do I need to report, and what do I face if I am not compliant? From a timing standpoint, intermediaries will have to report within 30 days beginning on the day after the reportable cross-border arrangement is made available for implementation, or on the day after the reportable cross-border arrangement is ready for implementation, or when the first step in the implementation has been made, whichever comes first. The directive is to be transposed into domestic laws this year, and the first reporting is due on the 31st of August 2020, with the first quarterly exchange of information to take place on the 30th of October 2020. In terms of penalties, Luxembourg draft legislation proposes fines of up to euro 250,000, which would be levied where intermediaries and/or taxpayers fail to comply with their reporting obligations in Luxembourg. As an organization, how have we prepared for that? As you will have understood by now, the primary risk of this directive, as and when it will be rolled out in various EU jurisdictions, is that we may be faced with over-reporting or multiple reporting which may on an EU scale provide distorted and inconsistent information due to the different levels of access to information of each involved intermediary. As a firm, we have decided to tackle the issue by developing an IT application that aims at connecting all the intermediaries involved in a given cross-border arrangement, so that the reporting responsibility will ultimately fall on a single intermediary. Conclusion. This new amendment to the Directive on Administrative Cooperation therefore goes even further into the disclosure regime and is built around hallmarks that are yet, for most of them, subject to a main benefit test. It sets a fairly high standard to be met for the cross-border arrangement to be reported. While the first reporting will be due in less than a year, it's vital to remember that all arrangements set up after 25th of June 2018 may potentially be captured by the directive. As such, it's key to ensure that proper tracking tools are set up. Now is therefore the right time to get fully prepared for these new disclosure obligations. And if you have any questions, feel free to get in touch.